promise, it's like they're intentionally trying to piss me off. I promise. They're looking to piss me off. They have to be. This has to be the goal. We about to just jump into it. So this is my exhibit MRE. This is my master record. My master evidence record. This is number 122. This is 122. This is that entry. Date: received September 29th, 2025. Meter stamp September 16th, 2025. Type of action: letter from the Department of Health and Human Services, Office for Civil Rights. Description: blatant disregard for the harm caused by their violation of oath. The returned submission of plaintiff's complete federal complaint further solidifies obstruction, fraud, misconduct, and willful harm, shifting accountability from themselves onto procedure. On August 1st, 2025, this is the little note section for this entry. On August 1st, 2025, defendant received a formal notice of claim explicitly notifying them of a pending federal lawsuit and provided them a 15-day deadline to respond. That deadline expired on August 15, 2025, without rebuttal, placing HHS in administrative dishonor and default. On August 30th, the full federal complaint was mailed. In September 2025, HHS returned the submission with a rejection notice alleging lack of clarity. This response is both irrelevant and procedurally void. The unrebutted notice of claim already binds the record, and the federal complaint cannot be undone by clerical maneuvering. Let the record reflect: I have cited and preserved the submissions with tracking and verified delivery. The willful disregard of evidence and the attempt to switch narrative by sidestepping liability. This demonstrates not confusion but deliberate misconduct. It further highlights the refusal to account for the harm inflicted through the violations of oath and lack of accountability. This return notice therefore stands only as further evidence of obstruction, dishonor, retaliation. It would be preserved for the evidentiary record to demonstrate the defendants attempted to sidestep liability after default already had been established. That was in September. Today, October 20th, I received an email from them. The entry number is MRE 136, October 20th. Type of action: email from the Department of Health and Human Services, Office for Civil Rights. Description: determination for complaint number CU 25640-965. On October 20th at 10:07 a.m. Standard Eastern Time, the Department of Health and Human Services, Office of Civil Rights, transmitted a message stating, "Thank you for your complaint filed with the U.S. Department of Health and Human Services, Office for Civil Rights. We have carefully reviewed your complaint. Please find your determination attached to this email." The reference attachment, C409565CL2C PDF, was inaccessible by both preview and download, rendering the alleged determination undisclosed and unverified. This response directly contradicts the prior communication from HHS OCR dated September 16, 2025, which the same office explicitly stated no complaint had been received and directed a resubmission. Within the same time frame, the original federal complaint, within the same submission, the complete federal complaint naming HHS as a defendant was unlawfully returned as if such an action could nullify their status as a named defendant. The sudden issuance of a new transaction number and so-called determination following the escalation to the Supreme Court of the United States indicates the post-hoc record manipulation. By fabricating acknowledgement of the complaint after months of claim non-receipt, HHS OCR has created a false appearance of administrative compliance while continuing to obstruct lawful remedy and suppress evidence. This act constitutes administrative fraud, obstruction of justice, and retaliatory interference under the color of authority in violation of 18 United States Code 241, 242, and 1503. the deliberate attempt to construct a fraudulent record of due process after returning my lawful filing amounts to psychological warfare and continued retaliation. Every entity, corporation, organization, and court that has sworn an oath to uphold the Constitution and human rights has instead violated those very principles. The unlawful return of my federal complaint only reinforces their liability, as they remain unaware of the complaint's full evidentiary context, further validating every allegation I have placed on the record. To really be paying in my face like this is insulting as fuck. And I don't even think that people are really able to grasp how much they be playing in my motherfucking face. I don't even think they're grasping how much they play in my face. And it's like, maybe I'm not being clear enough when I say that my entire evidentiary record proves the claim, solidify everything that I'm already bringing to the internet, and they still do these things. Yes, I'm irritated as fuck, because of what are you talking about? There's a settlement clause for a reason. Once I made it to district court, it was too late. It was too late. Once they were notified via the notice of claim, before the damn federal complaint even made it to court, was their last chance. And now people, they're panicking. They have to be panicking, because I don't believe in coincidences. So you're telling me, after I escalate to the Supreme Court of the United States, now all of a sudden I have an imaginary motherfucking case. I got an imaginary complaint open. Well, in September, y'all ain't never received shit from me, and I have that shit in my evidentiary record. I would go digging that shit out, but I don't fucking feel like it, and I shouldn't fucking have to fucking prove the point that's already been proven. Y'all already fucked up, and the fact that y'all just try to save face and ass like this is insulting to me. It's very insulting to me, especially when this has been ongoing for so long, and everybody already had the chance to do the right thing. And I expect more of the defendants to attempt these tactics, because this is not even the only corporation, entity, or organization, whatever you want to call them, to return the complete federal complaint. Like it was just going to remove them as a defendant or something. Fried, retarded, fraudulent. These were lawful notices naming these individuals as defendant in a federal complaint. And they still playing in my face. Y'all... I'm annoyed, and I'm annoyed for a lot of reasons. I can't even break down all the reasons why I'm so frustrated. More than anything, for y'all to really be trying to save face after they kidnapped my child, and y'all received a notice of claim before I even motherfucking made it to court, and nobody fucking did the right thing. Y'all was still violating y'all oaths. Y'all still was playing in my face, and now y'all trying to turn around and do what exactly? Please stop playing with me. I keep telling y'all got the wrong one. Y'all been had the wrong one. And yes, I do believe the pressure is finally starting to be felt, but it's too late. It's too late. My girl's going to be here SAP and ask for remedy. And all of y'all will be held accountable, because y'all did this.